Energy media is reporting on the story that broke last week that at the Imperial Oil's Kearl Oil Sands plant in northern Alberta had a rather significant leak starting in May of 2022. And the Alberta Energy Regulator didn't inform anybody, didn't inform the local communities, didn't inform the general public, as it's required to do, for 9 months. And the only reason they did that, it appears, is because in last month, on February 4th, there was a spill of 5.3 million liters of contaminated water from a storage pond. So I'm going to talk to Drew Yewchuk, who's the staff lawyer at the Public Interest Law Clinic at the University of Calgary and the author of the ABLAWG post, The Alberta Energy Regulator and the Disclosure Without Delay Rule in Freedom of Information Act. So welcome to the interview, Drew.
Thanks for having me on again.
Now, there's a lot of criticism of both the company and the regulator over this spill. And certainly the Fort Chipewyan First Nation is upset about this because, you know, they live in the immediate vicinity and they're the most immediately affected for sure. And they didn't get any notification. So maybe explain to us, what is the regulator required to do under law?
So there's a section in the Freedom of Information Act that's fairly different from the rest of what's in the law. Most of it requires someone to make a request. So you have to pay your $25 fee for general information or no fee for personal information and send a request to a public body who then process it. There's long timelines and everything. Section 32 is very different because it's, I could describe it as either an emergency information rule or an anti-cover-up rule, that when there is a threat to the environment or a risk to the environment or public health and safety, the public body has to disclose information right away and overlook some of the redaction rules that exist in the Freedom of Information Act that can override even personal privacy. So they have a pretty clear duty when there's a risk to the environment to disclose stuff. And I've bothered the Alberta Energy Regulator about this before in relation to other topics. And this is a really clear case where I think they had to disclose to the public. This is obviously a risk to the environment and to public health and safety. I know Imperial is insisting that there isn't any harm yet, but no one can argue that there's no risk.
Well, I interviewed toxicologist Mandy Olsgaard yesterday, and she noted, and in fact, the AER notes in its information it has released, is that the level of toxic chemicals in this effluent, in this seepage that was released, exceeds standards for human consumption. So I don't know how you define is human risk, the degree at which you begin to worry about this, but clearly the standards in place were breached, were exceeded, and therefore it seems incontrovertible. Shouldn't be controversial that people should have known about this. So I'm curious, before we get into what you've done in this case, what did you do in other cases where you brought this up with the regulator? What was their response at that time?
So the previous one related to sulfolane, a sour gas treating chemical, which had a big plume under a plant somewhere. And they said, that's not a risk to the public at this moment because it's not getting into anyone's drinking water. It's underneath a huge plant, but we don't have to tell the public about it because it's not getting any worse. It's just sitting there right now, which I didn't find incredibly compelling, but that was as far as it went in that case. But this one, it's going into the water. It's either going into the water or it's going into the water pretty soon because it is running off site and Imperial is not able to control it. You also said that the leak or the 5,300 cubic meters escapes on the 4th. It apparently happened on January 31st, which is Imperial's most recent statement, and that they didn't notice till the 4th.
Gotcha.
Who knows what exactly is going on over there?
One thing I should point out is that the mechanism for the leak And there are two releases here. One is the first one that started in 2022, that the AER refers it to as release 1. And then there's the overflow of the storage pond with the 5.3 million liters. That's release 2. So for release 1, what happened was in the tailings pond, there was the tailings pond water was seeping out of the pond, and it was mixing with the groundwater and then coming up to surface. And some of it was on the site of the plant and some of it was off the site of the plant. And there are rivers and water bodies that are nearby, and they may not have detected it yet, but maybe they will, or maybe before they get it stopped, it'll get in there. Certainly, it looks like there's no excuse for not informing the local community at a bare minimum that they should be careful.
That's exactly how I would see it. And one of the also confusing parts of this is that the AER maintains a compliance dashboard where they tell people about releases. And one of them that's very funny in retrospect is from March 2022, where they reported a release of 0.002 cubic meters spilled crude bitumen by Imperial. So a spill as small as a tiny fraction of a cubic meter got on this compliance dashboard, and they didn't say anything about this leaking tailing pond. I don't understand how that can make any sense.
Now, you've sent a letter to the Freedom of Information Commissioner. Is that correct?
Yeah, the Information and Privacy Commissioner.
Right. And what did you ask for in that letter?
I asked for an investigation, and I don't have any personal right to demand an investigation because I haven't made a request, but the commissioner does have the power to conduct this. And I think that in their role as enforcing and protecting the Freedom of Information Act, they do have a responsibility to engage here, because Section 32 does not appear to be followed at all. And the commissioner has extensive investigative powers. They can compel testimony. They can compel the regulator to provide them with documents, unredacted, other than, unfortunately, solicitor-client privilege documents, because they can't pierce that in Alberta. But they can get a pretty good set of records from the Alberta Energy Regulator and figure out what happened and how a decision was made in regard to Section 32 here. And not quite going off topic, but the AER has had problems with this for a while. I mentioned the sulfolane plumes. There was a sulfolane plume before that did get into people's groundwater before the AER told anyone. And there was an incident in June 2022 where wildlife contacted two tailings ponds, one from Suncor and one for CNRL. And that is all the information that has been provided. I have no idea what kind of wildlife. I have no idea how many. I don't know how the regulator found out or what they're doing about it. They just marked wildlife contacted substance on the compliance dashboard, and that's all they have.
One of the points that came out during my conversation with Mandy Olsgaard is that when she was the senior toxicologist at the regulator, she and a colleague spent 2 years working on a set of objective criteria for measuring human, health risk, and it never got completed and never got implemented. So, without that, essentially, whether the regulator considers this a risk or not, there is no objective measurement. It comes down to the expertise and the experience of the individual toxicologist or staff at the AER. So if you have one staff who has a very low tolerance of risk, you get you get better communication or better investigation. And if you have another one who has a high tolerance of risk, says, well, experience says we don't have to worry about that, then you get less communication and less information. And that seems to me, from a regulator, that is a very unsatisfactory way to approach these kinds of issues that have implications for human health, biodiversity, the marine ecological systems, wildlife, on and on and on. It just seems a little too loosey-goosey.
And even that would be better than I think what we're getting, because nobody might be making that decision at all in the AER. They might not have anyone assigned to look at these and say, do we have obligations under Section 32 of FOIP? Do we have any emergency requirements to provide information? They might only be considering if it's their job to provide information about this at all. And another example was when in 2020, I think. Give me 1 minute. Yeah. In May 2020, birds landed in the Curl Imperial Pond. The AER did not provide the public all the information it had. It knew at one point by May 7th that 81 birds were dead on site, and Imperial had reported that to the AER. And the AER's key messages that it provided to media inquiries was Imperial, here I'll find the exact quote, Imperial initially reported finding approximately 35 deceased birds. It's exactly true. That was the initial report from May 4th. The AER knew more than that from Imperial by that point. They decided it wasn't their job to tell anyone.
Well, I can't help but speculate, that the effect of the I believe it was 2017 when 16 ducks, there was a small number of ducks, died on a pond, and it became an international news story, if you remember that, and brought a lot of heat from various environmental activists. And it almost seems like it makes, I don't know, that I shouldn't say, because I'm speculating that might have had an effect on that decision. So, but let's consider that context.
And I think I remember the 2007 or 2008 Syncrude landing. That was the huge one. I think 1,600 ducks went down. That takes 2 years to prosecute. And then in 2015 or 2016, I think 31 blue herons die in a tailings pond, but I can't remember whose it was. And there's other smaller bird events, notably, and here, if we want to get a little conspiratorial, and I will, the 2008 Syncrude one was called in by a contractor on site for Syncrude. So not a full employee, but a contractor who's still anonymous. No one apparently knows who it was. And in February, this is Imperial, cut their number of contractors on staff. They reduced their staffing at Curl. And they knew this thing was leaking already for 9 months. And why did you decide to have less staff on site? That doesn't make any sense to me. There might be an innocent explanation for it, but it seems weird.
Well, the various issues we're discussing at the moment would suggest, we don't know that it was a deliberate attempt to evade information, but at the very least, the AER should be more forthcoming with information so that, experts like yourself or Mandy Olsgaard or the First Nations who live up in there, they shouldn't be guessing. They should have a full access to the information that is available. None of this is commercially sensitive. It's not like there's a competitive advantage that somehow Imperial Oil will be put at a competitive disadvantage. So what could possibly be the rationale for not disclosing all of the information in a timely fashion?
And my theory from the AER records that I've sorted through over the years and the FOIP requests I've filed is their determination to present themselves as a world-class, extremely responsible regulator. So when something goes wrong, they would prefer that people don't really know about it, because it makes them look bad as the regulator. They tell people, we have such good environmental regulations, this stuff just doesn't happen. So if they can get these things cleaned up, or they can get these things handled before many people find out, they like to do that. And that's one explanation for why the stuff on the compliance dashboard overwhelmingly looks like someone spilled 5 drops of oil and we got it cleaned up immediately, because that makes them look really effective. But when something like this happens, nothing. Because imagine in a different scenario where the second release doesn't happen, and in January Imperial somehow gets the seepage handled. When would we have found out about it? It seems like the answer might be never.
And I think there's some bigger context here that I discussed with Mandy in the Energy Talks podcast, so you can see it there. And yes, also in an
I did watch it. It was a great interview.
Well, thank you. And the point that was made is that Alberta has terrific environmental legislation, policy, and regulation. Where it falls down is in the implementation of that on the ground, how it's administered. And there's a big gap. And there's actually a report that was done on this for the Canadian Association of Petroleum Producers that compared Alberta's regulatory regime to other countries that extract oil and gas, and Alberta came out as tops in the world, but they only were restricted to design, evaluating design, not performance. And it's the performance that consistently gets criticized by people like yourself and Mandy and Mark Doran, because they aren't applying the regulations in the way they, in a consistent fashion. And it looks like, and optics count here, it looks like they're trying to cover up and minimize these kinds of events.
Absolutely. That problem is very common across environmental law in all jurisdictions. Alberta has it, I would say, pretty much particularly bad, but that's common in Canadian federal law too. The Species at Risk Act does not get the enforcement that it should. There are forestry protection rules in BC that don't get the enforcement that they should. So Canada has a really huge gap between what is described by our environmental laws and what happens, which can turn out to look shockingly different from what the law says.
Well, Drew, thank you very much for this. Always appreciate your insights.
All right. Thanks for talking to me. And I'll be back on sometime to talk about the Mine Financial Program, Security Program.